My name is Toby Hedworth. I'm the head of Trinity Chambers and I'm a member of the Civil Liberties and Human Rights Practice Group. Welcome to our Civil Liberties webinar, the latest in a series provided by the Practice Group. You will hear in due course from Patience Abladey, speaking about false imprisonment and unlawful detention in police custody. Shada Mellor in respect of Article 2 and inquests, and R.Crowe on the subject of misfeasance, malice and mishandled pleadings. But we start with my contribution, which is an unlawful arrest update. Can I begin with some perhaps wonderful levity provided by the case of Pyle, and it would be a grave injustice not to repeat the opening paragraphs of the judgment. Cheryl Pyle brings this appeal to establish the liberty of inebriated English subjects to be allowed to lie undisturbed overnight in their own vomit-soaked clothing. Of course, such a right, although perhaps of dubious practical utility, will generally extend to all adults of sound mind who are intoxicated at home. Miss Pyle, however, was not at home. She was at a police station in Liverpool, having been arrested for the offence of being drunk and disorderly. She had emptied the contents of her stomach all over herself and was too insensible with drink to have much idea of either where she was or what she was doing there. Rather than leave the vulnerable claimant to marinate overnight in her own bodily fluids, 4 female police officers removed her outer clothing and provided her with a clean, dry outfit to wear. The claimant was so drunk that she later had no recollection of these events. It is against this colourful background that she brought a claim against the police in trespass to the person and assault, alleging that they should have left her squalidly and unhygienically soaking in vomit. Fortunately, because this appeal will be dismissed, the challenge of assessing damages for this lost opportunity will remain unmet. And so it began. The outcome, as one might have expected, was that those officers were found neither to have assaulted the claimant or somehow violated her human rights. They took good care of the claimant, her medical needs, her hygiene and her welfare. Mr. Justice Turner declared much of the claim risible, including the suggestion officers should have simply monitored the claimant in her vomit-soaked clothes until she could remove them herself. The judge even described as brave the claimant's main argument that she should be allowed, as part of her right to liberty, to lie undisturbed in her own vomit. The outcome of the case was perhaps clear when my lord said, "I note, although it forms no part of my reasoning, that some members of the public may well have found it to have been a grotesque result if a woman who has rendered herself insensible through drink, abused an innocent taxi driver, behaved aggressively to police officers trying to do their job, and vomited all over herself, should then be found to be entitled to compensation, because those same officers, as an act of decency, had then changed her into clean and dry clothing, at a time when she was too drunk to know or care." So, that's the first point. Point 2, inadequate investigations into certain complaints. Following the John Warboys case, an increasing body of claims against police forces were brought for their defective or otherwise inadequate investigation of certain criminal complaints, principally rape cases. 2 noteworthy cases arise in this field. In the European Court of Human Rights, case of Y and Bulgaria, the court awarded €7,000 for failure to adhere to minimum requirements under the freedom from torture and inhuman or degrading treatment provisions. The court set out what it saw as the minimum requirements of ill treatment contrary to Article 3. Curiously, in what is a distinction with the domestic law, there was no overt consideration as to whether the alleged failures were operational or systemic, as was adopted by the UK Supreme Court. It is plainly the view that there will remain a domestic requirement that serious failures that are purely operational must be, and I quote, egregious and significant, and not merely simple errors or isolated omissions. There were material and obvious failures, but not such as to represent egregious conduct or conduct which caused serious and significant distress. The Northern Ireland High Court awarded £16,500 for breach of Article 3 in respect of a failure by the PSNI to conduct a proper investigation into the reported rape of a 22-year-old woman. The failures included failure to seize CCTV or conduct house-to-house inquiries, failure to follow up the claimant's assertion she had left personal belongings in the place she was raped, failure to consider the claimant's diary, failure to follow up text messages to the complainant asking her not to proceed with the allegation, failure to speak to witnesses, failure to submit evidence for analysis, and others. The failings were found to be serious, and the combination of failings led to a conclusion the investigation simply was not effective and invariably, therefore, in breach of Article 3. The judge notably considered that while some upset was caused, the significant deterioration in the claimant's condition would have happened even if the investigation had been flawless. The judge therefore awarded £16,500. Third update point, the Court of Appeal held that a system that deploys automated facial recognition technology may constitute an interference with a person's human rights. Article 8, respect for private and family life, which is not in accordance with the law, but would be proportionate if a sufficiently narrow local policy was promulgated and followed. There was no clear guidance on where the technology could be used and who could be put on a watch list. A data protection impact assessment was inadequate and not compliant with Section 64(3) of the DPA. The force had not taken reasonable steps to investigate whether the technology had a racial or gender bias, as required by the public sector equality duty. Next, strikeout and acts versus omissions. Two cases in this debate were recently decided, and they involve the familiar debate between when officers can be liable for positively creating a danger or making a situation materially worse as compared merely with refraining from protecting someone or something. In Tyndall, police sought to strike out a claim which alleged that the police's removal of a driver who had been warning traffic of accident debris and actions concerning a warning sign were positive steps, thereby rendering the police potentially liable. The court refused to strike out the case on the basis that there was no duty in negligence. The court said that the legal position was that although there was no general duty to protect persons from harm, the police could come under such a duty when they took steps which made a situation worse or positively created a danger. In the case of R, police sought to strike out a claim which alleged that they were liable in circumstances when they were said to have created a danger. The driver of a cargo lorry was arrested, and following his detention, the cargo was stolen. The judge sought to disentangle some of the case law. The court found that it was at least arguable, and therefore a matter for trial, that the police assumed a duty of care to keep the lorry safe. The judge held that it was arguable that the police had assumed responsibility to protect a person from danger, or did something to prevent the driver from protecting his property from danger, or had a special level of control over the source of the danger, or otherwise the police's status created an obligation to protect the claimant from the danger of theft. This case, on a thorough reading, truly indicates just how open the question remains as to when the police will be liable for damage caused by a third party, and it is alleged that the police could or should have prevented it. Fifth, data retention. The High Court considered how long the police could hold data about a person who might be vulnerable to radicalisation. The court determined in this case that the police's continued retention of data concerning a teenager was contrary to both the Data Protection Act and Article 8. The key factor in so deciding this was that the police's retention of data must be proportionate, which is fact-specific. Police forces cannot simply assume that they will always be permitted to retain data for 6 years, or that they can follow minimum retention provisions in policies without a proper analysis of proportionality. Sixth, a deprecation of the freeze-frame approach in the case of good enough. Judicial hatred for frame-by-frame analysis of events that is often adopted by lawyers came to the fore. The High Court expressed its disdain for such an approach. Events, they said, should not be analysed in isolation, but needed to be seen as part of the unfolding events that faced the officers concerned. The court said of the claimant's careful frame-by-frame analysis of the officer's actions that, and I quote, "This is just the sort of frame-by-frame examination of offence, the deployment of which the courts have so frequently warned against. The actions of the officers were taken over a matter of seconds in a highly stressful environment in the hours of darkness, and not over a period of 2 days of clinical analysis in a brightly illuminated courtroom. This approach falls once more into the trap of relying too much on retrospective and leisurely forensic analysis rather than a realistic appraisal of his state of mind over a matter of seconds." Furthermore, the court warned practitioners against placing too much emphasis on incomplete record keeping by officers, particularly where the record simply omits certain details, and the court reminded practitioners that a number of reasons may exist as to why there was such a deficiency. 7. The true reasons doctrine. An immigration detention case involved a claimant, H.S., who alleged that his detention was unlawful because officers who arrested him gave incorrect reasons for his detention. The claimant alleged, in short, that officers gave vague reasons for his arrest, for example, his associates and his character, whereas the true reason for his arrest was intelligence, showing he was associating with other criminals at an inappropriate bail address. The court found that the arrest and detention were thereby unlawful, and there will be a great many cases in which police withhold from some suspects the true reasons for their arrest. anxious scrutiny needs to be afforded to every case to consider whether this is the case, especially in intelligence-led arrests. Number 8, the high bar. 3 recent cases appear to determine almost authoritatively that there is a high bar in establishing the necessity to arrest a person. The cases of M.R., Rashid and Ray. M.R. considered principally the proper approach on appeal to unlawful arrest cases. Mrs. Justice Thornton opined that a decision on the existence of reasonable grounds as to the need for arrest is treated as a question of law rather than of fact, although it will involve an evaluation of the facts and, in many cases, a weighing of different factors. An appellate court is likely to be slow in practice to interfere with the trial judge's conclusion. Thornton J. thereafter, in this case, decided to form her own view on the matter in question. There had been, she found, no objective necessity to arrest an individual who had voluntarily attended a police station in respect of an allegation of harassment, notwithstanding the fact that the low threshold required for the arresting officer to have reasonable grounds to suspect the commission of an offence had been crossed. The test of necessity was considered to be a high bar designed to tighten the accountability of police officers. In the present case, the police had the claimant's phone number, he attended when requested, and it seemed the police had given no thought to alternatives. The obvious alternative to arrest had been to interview the respondent, establish his identity, and obtain his phone. Any difficulties in that regard could have necessitated his arrest at that point, but not before. The case of Rashid involved a general practitioner arrested during an investigation into fraudulent cash-for-crash claims. Police found appointment diaries concerning the GP in the car of one of the conspirators and at the office of the company making the fraudulent claims. The diaries showed appointments for the GP to examine potential claimants, up to 50 in a day, booked 10 minutes apart over an 8-hour period. Medical experts advised the police that such assessments should take 20 to 30 minutes and that the GP's reports were of poor quality. They also advised that £250 to £300 per assessment was a reasonable fee, whereas it had appeared that the GP was charging significantly more. The police also found that the GP had been making payments into the bank accounts of the fraudulent claims company and one of the conspirators. They arrested the doctor in March 2012, visiting his home at dawn and seizing his mobile phone. They also had warrants to search 3 of his premises. He was released on bail the same day. The CPS decided he should not be charged. The recorder, Ben Nolan, Queen's Counsel, found that the arrest was lawful, and so the claimant appealed. The claimant succeeded. There had been no reasonable grounds, said the Court of Appeal, for believing that it had been necessary to arrest the claimant. Given that the police had search warrants for his premises, the only evidence that could necessitate his arrest would be evidence concealed on his person, which in practice, in his case, meant his mobile phone. The police had to satisfy the condition in Section 32(5) of the 1984 Act, namely reasonable grounds to believe that the suspect might have concealed on their person something for which a search was permitted. As the arrest took place at 6 a.m. when he was in his nightclothes, and the police had seized his phone from his bedside table, it was doubtful that Section 32(5) was satisfied. Further, the police had anticipated that the doctor would be cooperative. In those circumstances, an arrest could not be reasonably thought necessary unless the officer had asked him to hand over his phone or some other item of potential evidence reasonably believed to be concealed on his person, and he had refused, or given the appearance of refusing to cooperate. The implications of this finding by the Court of Appeal was that there is a high bar. Mr. Justice Lavender expressed the requirement for reasonable grounds for believing an arrest is necessary as imposing a comparatively high hurdle, he said. The bare suggestion that inviting the claimant for a voluntary interview would have tipped the claimant off was simply not an inference the judge was prepared to make. Further, the defendant had mounted the illegality defence, saying essentially that because there were grounds to suspect fraudulent activity, it could be said that the claimant's own illegal activity led to his arrest. There is, of course, nothing to prevent this defence being raised in future cases to try and deny claimants compensatory damages, but it's an extremely difficult argument to mount. The third point to emerge from Rashid is that nominal damages as an argument, expressed most clearly in the case of Lumber, where the person could and would have been arrested lawfully in any event, was adopted. The judge said he was not satisfied that there were any grounds for believing it was necessary to arrest, and therefore there was no scenario in which the Lumber argument could succeed. This, whilst unexciting, is a helpful clarification for cases involving an allegation that arrest was unnecessary. The third of those cases, Ray, repeated the high bar requirement in proving necessity to arrest. It concerned the arrest of a small group of protesters before an organised march through a city centre. The court found that their arrest had been lawful, where the police had information that they planned to commit violent disorder, and they were not answering questions about their intentions. The case is worth mentioning for its lucidity and precision in summarising the recent jurisprudence. The court reviewed the cases of Hayes and Merseyside Police, R against the Chief Constable of Surrey, the Commissioner of the Police and MR, and Rashid and the Chief Constable of West Yorkshire. From these, the following could be distilled. The test, above all, is practical, not a theoretical exercise. It's to be applied to a real-life process or moment of decision. That is why context is so important. The test has to be applied on the basis of what is known at the time by the police and the situation faced by them, without the benefit of hindsight. It must also be applied to the particular circumstances of the arrestee. Context is also why the question of alternatives inevitably arises. The test does not mean that there must be no feasible or viable alternative, or that arrest must in every case be a matter of last resort. Rather, it must be the practical and sensible option. The definite article has a limiting effect. So, for example, while it may not require interrogating a suspect as to whether he will attend a police station voluntarily, it is at least relevant to see whether that is a practical alternative. Again, with a suspect who is expected to be cooperative, an arrest cannot reasonably be thought necessary unless the suspect then refuses to cooperate or gives the appearance of refusing to cooperate. In many instances, the alternatives will require no more than a cursory consideration. But a belief not based on some evaluation of the options is unlikely to be found to be based on reason. A judge should hesitate to second-guess the operational decisions of experienced police officers, but there must be a rational justification for an officer to reject alternatives to arrest. And the court concluded that the function of the court is to hold the police to account, but not to subject the process of arrest to the rigour of a public law reasons challenge. The test of necessity is a high bar, more than simply desirable or convenient or reasonable. At the same time, while it sets a high objective standard, it is being applied to a unique form of operational decision-making. It is uniquely momentous as a summary deprivation of individual liberty, hence the high standard of accountability. It is also uniquely vital for the operational public interest purposes reflected in the preventive reasons, hence the significance of real-life practical context. Though there is technically no philosophical room for manoeuvre in a binary decision, where it is either necessary to arrest or unlawful, i.e. necessary not to arrest, the job of the court is not an abstract thought experiment. It is a distinctively practical balancing exercise upholding individual liberty and police accountability on the terms of the operational realities of public interest policing and the choices available on the ground. And finally, point 9. Following the High Court case of Rees and the Commissioner for the Metropolis, the Court of Appeal waded into the topic of damages following findings of malicious prosecution and misfeasance in public office against a police force. The appeal and cross-appeal before the court were ultimately dismissed, but the court helpfully grappled with issues of damages for loss of liberty, interest, and awards of exemplary damages. It is worth a very thorough read. Thank you.
Hello, my name is Patience and I'll be speaking on unlawful detention in police custody. I'll also briefly cover detention of those with mental health needs, and I'll also cover making claims where someone has potentially been unlawfully detained and the remedies available, namely damages and compensation and justice for human rights breaches, which have had a detrimental impact on a person's freedom and civil liberty. Claims for unlawful detention can be made across a wide range of circumstances, from unlawful detention relating to stop and search, to unlawful detention involving immigration matters, the prison service and border control officers, though on this occasion I'll be concentrating on unlawful detention in police custody. The general principle is that in order to detain a person lawfully, the police must have a reason for doing so. This might either be for public protection or where an individual is detained for their own protection and safety, perhaps. Police powers are largely derived from the Police and Criminal Evidence Act 1984. Herein I'll be referring to it by its shorthand of PACE. Detention is governed by quite a few provisions of PACE, and actually there are no fewer than 38 provisions within PACE which deal with detention, though I don't propose to address them all on this occasion. Ordinarily, if one can show the arrest was unlawful, the detention will also prove to be unlawful. However, a point of note is that if the arrest is lawful, it doesn't necessarily follow that the detention will also be lawful. Section 34 of PACE states that a person who is arrested must not be kept in detention save in conformity with the myriad of provisions of PACE. And if the custody sergeant becomes aware that grounds for detaining someone no longer exist, then they must be released. That's section 34, subsection 2. The example of a motorist arrested for drink driving who then provides a negative intoximeter sample is commonly used to describe the situation in which release should immediately follow. Essentially, there's a requirement for continuing determination of necessity throughout the time in custody, and that should be regularly reviewed. When a person is arrested that's without a warrant or on a warrant not endorsed for bail, the custody sergeant must first consider whether there is sufficient evidence to justify a charge for the offence for which he was arrested. The custody officer may then detain the suspect at the police station for such period as is necessary to enable him to do so. Additionally, where there is insufficient evidence to charge a detained person, the person must be released on bail if the preconditions for bail are satisfied, unless the custody sergeant has reasonable grounds for believing that his detention without being charged is necessary to secure or preserve evidence relating to an offence for which he is under arrest, or to obtain such evidence by questioning him. And that's section 37, subsections 2 to 3 of PACE. An obligation which is frequently flouted is the obligation to conduct reviews within the first 6 hours, and then at not more than 9-hour intervals from the previous review. That's section 40. This applies to each person in police detention. A failure to review is actionable. And in the case of Roberts, a full citation of the case is provided within the accompanying handout. In Roberts, it was found that a review was conducted 2 hours and 20 minutes late. However, the reviews can be postponed where they are not practicable, or the person is being interviewed, or the officer is not readily available. It'll largely turn on the circumstances of the individual case. A person may not be detained without charge for more than 24 hours, and that's from the moment they arrive at the police station or 24 hours after arrest, whichever is earlier. That's section 41, subsection 1. Those of you who watch 24 hours in police custody, I'm sure will be well familiar with that provision. The person cannot be rearrested for the same offence unless new evidence comes to light, and at that point, the detention clock would then start again. If the detention runs past 36 hours, the authorisation of a magistrate's court is required. Detention can be authorised up to a maximum of 96 hours, and persons detained under the Terrorism Act 2000 can be held for longer. In covering detaining those with mental health needs, I'll be covering proposed reform within this area. Part 4, Chapter 4 of the Police and Crime Act 2017 amended powers in the Mental Health Act 1983, which allowed the police to detain mentally ill people for their own safety. The reforms restrict the use of a police station as a place of safety for the purposes of detaining a mentally ill person. Subsequent secondary legislation, the Mental Health Act 1983, Places of Safety Regulations 2017, provided for rules about how those detained at a police station for their own or other safety should be monitored. The government's January 2021 white paper on reforming the Mental Health Act contains wide-ranging proposals to reform the Mental Health Act 1983. The white paper sets out the government's commitment to removing police stations as places of safety by 2023-24, so individuals are instead taken to health-based places of safety. The white paper sets out a number of proposals. Firstly, to help ensure that in future, all people in a mental health crisis are taken to a clinical environment where they can receive the care and support they urgently need. The government has committed to update sections 135 and 136 of the Act to remove police stations as a designated place of safety by 2023-24. However, of course, before they can do that, the system needs to be ready, and this will likely require new capital funding to be available to provide the estate and the space needed, including health-based places of safety in the areas that need them. And so whilst it's hoped this can be done by 2024, as is proposed, we'll have to see. The government aims to establish a national agreement between mental health services, social care and the police to ensure that people detained under Section 136 are safely and effectively transferred into health services in a timely way, while ensuring the ongoing safety of all concerned. Further information on places of safety is available in the library briefing on mental health policy in England. Finally, in turning to the all-important matter of remedies, the damages and compensation and justice for human rights breaches which have had a detrimental impact on a person's freedom and civil liberty. In essence, if a person's civil liberty or human rights have been infringed as a result of some form of police misconduct, in this case unlawful detention, then there may be an entitlement to compensation in the form of damages. Firstly, claims for unlawful detention have to be made within 6 years of the incident. That's not to be mistaken with the 3-year limit if it's a claim for personal injury whilst in police custody. And that's 3 years from the incident or from diagnosis of the injury. In terms of the time limit for a civil claim for unlawful detention, that's 6 years, so you have up to 6 years within which to make a claim. Though of course it's advisable to make a claim as soon as possible while any evidence is still readily available and memories of the incident remain fresh. As discussed previously, police officers should always fully consider whether there is a need to arrest. If they do not have a lawful reason for arresting and detaining an individual, then this could amount to false imprisonment. Alternatively, if it could be shown that somebody was held for longer than required, or that other realistic alternatives had not been considered, it could be classed as an unlawful period of detention. In respect of the assessment of damages and the approach by the courts, it is quite complex. The approach adopted by courts in the assessment of compensatory damages is that set out in the case of Thompson. Again, a full citation is provided in the accompanying handout. The guideline figure established within that case for straightforward cases is £500 for the first hour and then £3,000 for 24 hours. That case, of course, is from 1998, so adjusting these figures, the awards would be in the region of around £1,040 and £6,195 respectively, though of course that would need to be adjusted. There is a limited number of case law within this area, since damages assessment will always have to be tailored to the circumstances of the individual case. A court may award nominal damages to a claimant who has been unlawfully detained where the defendant could and would have detained the claimant in any event. That principle derives from the case of Lumber. In that case, the Supreme Court held that if an individual was unlawfully detained following a public law error, they are entitled to only nominal damages if they would have been detained in any event, and even if the error had not occurred. In other words, if the power could and would have been lawfully exercised, that is a powerful reason for concluding that the detainee has suffered no loss and is entitled to no more than nominal damages. In such circumstances, the claimant will have suffered no loss or damages as a result of the defendant's unlawful exercise of the power to detain. In the case of Parker, again, a full citation is provided in the accompanying handout. Parker provided a careful explanation of the Lumber principle. Essentially, in Parker, had the arrest by a police officer been conducted in accordance with proper procedure, it would have been lawful. It was held that substantial damages would not be awarded for false imprisonment where the police could establish that, had the defendant acted lawfully, the claimant would have been detained in any event because no harm would ultimately have been caused. While there may have been lamentable procedural failings, this did not mean there was actual loss. The test is what would have happened had it been appreciated what the law required. The crux of the test is essentially causation, and the principle has since been summarised as follows. Firstly, where unlawfulness is being proved, causation is relevant on the question of damages, because generally damages are dependent upon proof of loss. Damages for unlawful detention are meant to compensate the relevant individual for the loss of his liberty, and he cannot be compensated for the loss of something which he never would have enjoyed in the first place. Secondly, unlawfulness having been proved, compensatory damages therefore turn on the question of whether, being able to do so, the public body would have detained the individual. The defendant would then have to establish on balance that the individual could have been lawfully detained in any event. Thirdly, the issue of what the defendant would have done had it followed public law principles properly need not be evidenced if the answer is plain from the circumstances. Exemplary and aggravated damages are awarded to punish a defendant, in particular where there has been an abuse of power. They may be awarded against officers of the defendant where it's been proven that they acted in a high-handed, insulting, malicious or oppressive manner in relation to imprisonment, and that's the case of Thompson. In relation to the Human Rights Act, there is of course a different test, and that is set out in the accompanying handout. Thank you.
Hello, my name's Shada Mellor, and today I'm talking on Article 2, Inquests. Firstly, Section 1 of the Coroners and Justice Act 2009. When a senior coroner is made aware that the body of a deceased in the coroner's area has been located, they must act as swiftly as practicable to conduct an investigation into that person's death. If the deceased died a violent death or through unnatural causes, if the cause of death is unknown, or if they died while in custody or in state detention. Within an inquest, there are 4 statutory questions. Who was deceased? How, when, and where the deceased came by their death. How is usually the most controversial of those questions. There are 2 classes of inquest. We have firstly the Jameson inquest, and this can be done either with or without a jury. However, it is not the presence of a jury which extends the scope of the inquest. It is Article 2. And in a Jameson inquest, how is meant by what means. We then have a Middleton inquest, also known as an Article 2 inquest. And in those inquests, how is defined as by what means and in what circumstances. For practical purposes, there's also an important distinction regarding legal aid. For a Middleton inquest, legal aid is automatically granted. However, for a Jameson, it is not. Perhaps to give a clear indication of the difference between those 2 forms of inquest, we can take the Jameson case itself. This is a case in which the deceased died before the Human Rights Act came into force. And that's important because if the case came about today, it would actually be a Middleton inquest. In that case, the deceased died in custody by suicide by self-suspension. And the only question that was required to be answered was, is there any sufficient evidence of prison staff having a causative or contributory effect on the death? The Jameson inquest is a fact-finding and limited generally in those circumstances to the general regime. However, if this was in a Middleton inquest, the scope would be extended and more things could be taken into consideration, such as the reception of the deceased in custody or the prison, communication between the different staff, So as many of you know, there's different roles within a prison, so the communication between prison staff, medical staff and other staff, as well as training of the staff and any of the events leading up to the discovery of the deceased's body. Article 2 of the European Convention of Human Rights is the right to life, and it imposes duties upon the state. Firstly, have a negative duty, and that is to refrain from taking life except in exceptional circumstances described in Article 2. We then have the positive duty to protect the life in certain circumstances, and this can be broken down into the general duty and the operational duty. The general duty on the state to put in place legislative and administrative framework designed to provide efficient deterrence against threats to rights of life. Turning then to the operational duty, and that is in well-defined circumstances, the state should take appropriate steps and safeguard the lives of those within its jurisdiction. This includes to take preventative operational measures to protect an individual whose life is at risk, whether in public or not, in which the right to life may be at stake. We then have the positive duty to conduct a proper and open investigation into the deaths for which the state may be responsible. Those investigations should be sufficiently open to public scrutiny, being in terms of the investigation and the result itself, conducted by a tribunal that is independent of the state agents who may bear some responsibility for the death, that the relatives of the deceased should be able to take an appropriate role in those proceedings, and finally it must be prompt and effective. Now there are some limits on that scope. Primarily, the scope should be limited as to not impose an impossible or disproportionate burden on state agencies in carrying out their necessary functions, and must take into account the individual's right to liberty, Article 5, and private life, Article 8. It is common ground that there are certain well-defined circumstances in which there is a positive obligation on the part of the authorities, and often in those cases when there is a death, the duty to investigate is triggered. For example, we have deaths in custody, deaths in prison, deaths of those persons detained under the Mental Health Act. There appears to be a growing bound of case law in relation to those persons who are involuntarily in hospital. However, if they were to leave hospital, they would more than likely be detained. And finally, those in immigration detention centres. However, I imagine most of you be thinking that, of course, this does not apply to natural deaths in those circumstances. The features of Article 2 cases can be drawn from the case of Rabone, in which the Supreme Court derived the relevant factors from Strasbourg jurisprudence. And these factors are, firstly, the existence of a real and immediate risk to the individual's life. Secondly, an assumption of responsibility by the state for the individual's welfare and safety. Thirdly, vulnerability of the individual concerned. Fourthly, whether the risk is an ordinary risk or an exceptional risk. If there is an arguable breach of the positive obligation, then that triggers the duty to investigate. It's important to also note that these are the current relevant factors as enshrined in domestic law. However, it does not necessarily mean that the European Court of Human Rights will use these as a guiding principles in cases which have not yet been determined. This is the law as it stands. And in fact, this area of law is developing very quickly. So if we have a look at a couple of those factors, firstly, the existence of a real and immediate risk to the individual's life. The state agents know or ought reasonably to know of a real and immediate risk to the individual's life and are required to take such measures as reasonably expected to avoid that risk. If we break down a number of those words in that requirement, what does risk mean? Risk is significant or substantial. In the case of Rebone, which was a death by suicide, it was deemed that the risk of suicide on subsequent days was 5%, 10% and 20%, and that was deemed sufficient. We then have immediate. This is a present and continuing risk rather than an imminent one. The risk has to be to life rather than harm or even serious harm. And then finally, real. This is what was known or ought to have been known at the time, and that is important to avoid the dangers of hindsight. We then have the assumption of responsibility by the state for the individual's welfare and safety, including the exercise of control. This is factual, and there has to be some link between the risk and exercise of control by the state. I won't touch upon the third and fourth, but move to, if there is an operational duty, there must be an arguable breach to trigger the investigative duty. What does arguable breach mean? Well, it has been termed differently in case law. It has been said to be more than fanciful, a credible suggestion, or more than mere speculation. But from all those words, it can be seen that the threshold is indeed low. And that is deliberately done to avoid coroners falling into the dangers of determining the case before having heard the evidence. Finally, I'd like to discuss some specific instances which the Article 2 may arise. Firstly, we have cases of suicide. It's clear from case law that there is no general obligation on the state to prevent a person committing suicide, even if the authorities know or ought to have known that there was a real immediate risk. However, it is likely to trigger Article 2 if that person is under the control of the state. For example, think of somebody in prison. We then have physical illnesses. Article 2 does not apply to medical negligence except in very exceptional circumstances, namely, firstly, a specific situation where an individual patient's life is knowingly put in danger by the denial of life-saving treatment, or where a systematic or structural dysfunction in hospital services results in a patient being deprived of access to life-saving emergency treatment. And the authorities know or ought to have known about the risk and failed to undertake the necessary measures to prevent the risk from materialising, thus putting patient's life in danger, including the life of the particular patient concerned. The case of Rebone involved a claim for damages brought by the family of a voluntary psychiatric inpatient who committed suicide when staff authorised a 2-day home visit. The Supreme Court held that there was a positive duty to protect the patient in that case from suicide risk, which had been assessed as high. It is noted in the judgment that the reason the patient was in hospital was due to their suicide risk. We then have the case of Moran from this year, and that was whether an Article 2 inquest was required, following the death of a voluntary inpatient of a psychiatric rehabilitation unit due to an overdose of recreational drugs when she was at home in the community. It was held that the NHS Trust had not assumed responsibility for the patient and no operational duty had arisen, as there had been no real or immediate risk of which the Trust should have been aware. Finally, we have the case of Dove from September this year. Again, this is whether an Article 2 inquest was required. And that case concerns the death of a woman who had severe physical and mental health problems, including suicidal ideation and a history of overdosing. She was put on the employment and support allowance as she could not work. She was required to be assessed periodically as to her suitability. At the last assessment, she had made a request that she would be able to be assessed at home. However, the Department for Work and Pension did not action this request and still required her to attend in person. She did not. The Department for Work and Pensions then stopped her employment support allowance. 2 weeks after this happened, she committed suicide. There was an independent report finding numerous failures of the Department for Work and Pension. The coroner held that Article 2 was not engaged, and this was upheld by the courts on the following grounds: that the Department for Work and Pensions had not assumed responsibility for preventing the suicide of those who received funds. And secondly, she was not under the control or care of the state. And finally, errors of the Department of Work and Pension were human errors and not systematic. Thank you.
Hello, my name is R.Crowe, and my talk concerns misfeasance in public office. It's a tort that evolved over 300 years ago. It has its roots in the corrupt elections of the 1700s and took on new life when it was developed to tackle malicious and malevolent judges of the 1800s. Some 200 years later, in the early 2000s, Lord Stein definitively defined what misfeasance in public office was. And that was the case involving the Bank of England and is known widely as Three Rivers. Despite this rich history, the problems with the tort still pervade, much to the chagrin of the courts. With that in mind, this talk addresses three issues. First, the principles behind the tort. Second, the concept of malice. And third, common problems with pleadings. I will turn first then to what ingredients are necessary to make out a claim for misfeasance. Since the case of Three Rivers and Lord Stein's opinion, the tort of misfeasance consists of four key elements. The first is that the defendant must be a public officer, or otherwise an organisation that is vicariously liable for that public officer. This is rarely an issue, but where there has been any doubt in the past, a court has said it will interpret this requirement in a broad sense. For example, a local authority that is acting as a private landlord might meet that definition. Second, the conduct complained of must be in the exercise of public functions. This is a more nebulous requirement, but in broad terms, there has to be a link between the public office, in other words, what that office exists to serve, and the powers exercised from that office. Third, importantly, there must have been malice in the decision or act complained of. Now that's the focus of my talk, and I will return to it shortly. But the fourth and final requirement is that there must be proof of material damage. This means, as per the 2006 House of Lords case of Watkins, that this tort is not actionable per se, like battery or assault claims. That's a broad overview, but it is malice in its varying forms which requires a closer look, and which so often gives rise to difficulties. Malice. The issue of malice is the answer to the question, what on earth was that public officer thinking when they made that decision or did that act? It touches upon the state of mind of the proposed defendant. Indeed, one will recall the origins of the tort was in tackling malevolent judges and corrupt politicians. The tort demands some form of bad mindset in the broadest sense of a defendant. Now, the requirements for malice are tricky. It appears in two different forms: untargeted malice and targeted malice. Dealing with the latter first, targeted malice. This is made out where the conduct by a defendant is proven by the claimant to have been deliberately calculated to specifically intend to injure a person. This is rare. It's bad faith in its truest form, and bad faith itself is synonymous with dishonesty. That requirement was established in the 2008 case of Shada and Cumbria Police. In the case of Shada, a number of police officers themselves had been subject to disciplinary proceedings, but their superiors, regrettably, willfully disregarded fatal evidential flaws in their inquiry. When the officers sued and alleged misfeasance, the claim failed. I'll return to that in due course. The second variant of malice is untargeted malice. This is the far more common variant of the tort. Untargeted malice itself appears in two subforms. Either the public official acts knowing that he or she has no power to do the act complained of, or acts with a reckless indifference as to the lack of that power. And in either case, that official knows the act will probably injure the claimant. This is untargeted malice. Those requirements appear modestly straightforward, but they have proved problematic for lawyers and the courts alike. Not least because refinements have been applied to that test repeatedly over the years. For example, mere unlawfulness without more cannot found a claim in misfeasance. Even if someone acts well outside the strictures and constraints on their powers, if this is done out of inadvertence, mistake, or oversight, that's not enough to amount to misfeasance and malice. What's more, knowledge itself means actual awareness, and not necessarily the knowledge of an existing fact, or even knowledge of an inevitable certainty arising from a decision that's been made. Untangling all those glosses and requirements of untargeted malice can perhaps be best dealt with by the case of Musa and the Secretary of State for the Home Department. This was a 2009 case where, at first instance in the High Court, Mr. Musa was successful in his misfeasance claim. But when the Court of Appeal stepped in, his claim failed. The facts, in broad terms, were these. Mr. Musa was a Dutch national. He was, for reasons that remain unknown, mistakenly detained in immigration detention for over 4 months. The defendant was considering deporting him. Now, all of this took place despite Mr. Musa having an identity card in his possession and proof of his nationality. This, you may think, was an astonishing error. The Secretary of State, when this claim was brought, admitted unlawful detention. But they said, this is not a misfeasance claim. The learned judge in the High Court found that there had been a litany of errors on the defendant's part and a complete failure to consider the claimant's position in an adequate way. Importantly, the judge went so far as to find that some of the defendant's officers simply didn't care. This, the judge said, all amounts to misfeasance in public office. When the case arrived at the Court of Appeal, the court found there was no such misfeasance. This is because the judge had not made an express finding of reckless indifference as to the legality of the defendant's officer's actions, and no such indifference could be inferred from the facts that had indeed been found. At first blush, this appears a little difficult to reconcile with the initial finding that officers simply didn't care. But it in fact demonstrates that for this tort, there ought to be a link between the reckless indifference and the legality of what those officers are doing. In short, lawyers and courts need to bear in mind that mere failures are not enough, even if they themselves amount to unlawfulness. The malice requirement is key. Now, the waters become somewhat more muddied when the tort of misfeasance and its malice requirement is held up against malicious prosecution and the requirement of maliciousness within that tort. I won't delve into that in detail, but I will discuss briefly the intersection between the two torts by reference to a case that Mr. Hedworth, Queen's Counsel, mentioned earlier, and that's the 2017 case of Rees and the Commissioner of the Metropolis. In that case, a claimant succeeded in their claim for misfeasance, but remarkably failed in a claim for malicious prosecution. The facts were these. In 1987, someone was murdered. In 2006, an informant for the police gave information which implicated 4 individuals. All 4 were prosecuted. For some, there was evidence other than what the informant had to say about them, which implicated them in the murder. But for one, the only evidence against them was from this informant. At trial, the judge found that the officer in that case had improperly prompted the informant's evidence and stayed the prosecution against that one defendant. Irrespective of this, all 4 defendants sued the police. All failed in their claim for malicious prosecution, but one individual succeeded in their claim for misfeasance. The court approached the case as follows. First, for malicious prosecution, the judge found that the officer was not malicious. His motive, however misplaced, was to bring those he believed to be complicit in the murder to justice. But even if that was wrong, the Crown Prosecution Service had become the prosecutor in the case, and it was no longer the officer against whom the action rested. The judge then turned to the misfeasance claim and dealt with it in this way. First, the officer, in prompting the informant, was plainly and clearly exercising his public functions. Secondly, as to malice, this was again quite clearly made out because the officer was found to have deliberately breached guidelines and express instructions from his superiors, which he knew would undermine the integrity of the evidence. The officer must have known, concluded the learned judge, that these acts would injure the claimant because it would result in arrest, prosecution, and loss of liberty. Third, as to loss, the judge found that the CPS would have decided to prosecute 3 of the defendants, irrespective of what transpired between the informant and the officer. There was no loss. But for one claimant, the only evidence against him was from that informant who had been prompted improperly by that police officer. The judge therefore found that but for the officer's conduct, the informant's unprompted evidence would never have come about and the claimant would not have been prosecuted. On this basis, that one claimant's claim for misfeasance in public office succeeded. That case neatly demonstrates in the quickest of terms the difference in the malice requirement for misfeasance and the maliciousness needed to establish malicious prosecution. That was a swift tour of the requirements of the tort of misfeasance in public office, and I'll now move to the final section, which deals with pleadings, problems, and pointers. There are 4 key points to make in respect of pleadings. First, misfeasance commonly features alongside other causes of action: negligence, human rights claims, false imprisonment, and indeed malicious prosecution. I would encourage, in most cases where the facts disclose more than mere misfeasance, to include separate and distinct causes of action. This will protect claims where bad faith may prove difficult to establish within the malice requirements of misfeasance. But to be clear, the courts have explained repeatedly that there is a heavy burden and an onerous requirement when pleading misfeasance. It is not to be taken lightly as a secondary or tertiary cause of action. Second, it follows that particulars must plead and properly particularize a claim for misfeasance. If a claim is based on little more than inference because of lack of disclosure, for example, and that inference is equally consistent with oversight or negligence or mistake, that claim will be struck out. As an example, if a prosecutor within the CPS has been negligent or incompetent in the course of reaching a decision to prosecute, whether by failing to consider all the evidence or otherwise, that in itself cannot justify an inference of malice. The pleadings must, in every case, from the very beginning, set out in detail the basis for the allegations of misfeasance. The pleading must particularize why those officers and officials lacked the requisite power to make the decisions that they made or act in the way that they did. There must be a pleading, for example, that a public officer making an impugned decision or acting in a particular way knew that their actions fell out with their particular powers. And of course, there ought to be a particularization that the public officer knew their acts would injure the claimant. Now, on that last issue in particular, it is arguably not enough to say simply that officers must have foreseen a claimant would have suffered conditions such as depression or anxiety or stress. The pleadings must delve far deeper than that and explain how the public officer would foresee such damage arising from their decision or acts. Third, the pleading should actually identify the person or people said to have acted with such malice and to establish their bad faith. It's worth remembering on this point that an institution can only be reckless subjectively if one or more individuals within it acting on its behalf are shown to be subjectively reckless and their subjective state of mind has been established. Fourth and finally, where a defendant receives such a claim, the first thought must be whether that pleading meets the onerous requirements needed to make out a misfeasance claim. If it does not, a strikeout application should follow. Overall, misfeasance as a cause of action is useful. It's a great weapon and can be used creatively, but it must be used properly, and it seldom is. The courts are all too ready to strike out claims of their own volition, which do not meet the onerous pleading requirements. It cannot be a secondary thought when pleading it. Otherwise, where it has been mishandled, it will be struck out. Thank you.